Okay, so it breaks it down, and we start off with real property. And here's your chance. It says, it walks you right through it. I leave the following specific real property to the persons named. You put the name in one column, the description of the property in the next, and then you sign. So I leave to Jack the woodlot, and I sign it. I leave the homestead, to Sally, and I sign. I leave any other real property.
Did you just say I leave everything
You can. And you could do it in handwriting. And it's called a holographic. And a holographic is, you can say, I revoke all prior wills, I leave everything to my wife, and you sign your name and you date it. And the holographic will, the test for it is that the material aspects are in your handwriting and your signature is in your handwriting. Or if you can't write, there's another way to have a mark. But you get some beautiful wills, handwritten wills, in court. And my favorite, and I'm going to throw a little fun in, is I leave everything to Lucille, the love of my life. And then that's all crossed out. And then you have, forget Lucille. I now love Wendy. And then that's crossed out. And then finally, oh, forget it. I just am not lucky in love. I leave everything to the daughter I had by a previous girlfriend. But anyway, so we have an obligation to do everything in our power to honor your last wishes. And we will go out on a limb if it's in handwriting, but there are certain tests. This document is a main form that's on the internet. It's in the statute books. And basically it attempts to break down all the different types of property to jog your memories. What do I own, okay? And then it walks you through the signature requirements. And as you see at the end, it's the signature requirements you sign 3 times as the decedent, as the person, the testate, the guy or gal, the testator, the guy writing the last will and testament, or the gal. And then the witnesses sign 2 or 3 times too, and the notary signs a couple times. Why all that? It's called self-proved. And so say you've got all these signature requirements satisfied because you've walked through the signature requirements. I'm getting a little ahead, but I want to point out that once you get that signed, sealed, and delivered, many signed, sealed, and delivered, say there's a will contest, you bring it in and it doesn't get last formal, it becomes a will contest, it goes formal for a judge, and there's some contest around the signatures. Well, if you've had all these extra signings, then you don't need to call in your witnesses to testify. It's called self-proved. You're done. Your witnesses have obviously said, not once, not twice, but 3 times, you knew what you were doing, okay? Okay, so that's why at the end you're going to see so many signature lines, okay? For both the testator, and then the witnesses, and then the notary. And I throw them all in because I'm an err on the side of caution person. If one more signature is going to save you from having to subpoena a witness to get it in, and makes this all the more, my words, bulletproof, or protects it more, makes it more valid, instantly credible, why not? You're doing the signing once, why not do it 3 times, okay? But I just got ahead of myself, but that's what we'll get to at the end. So next is, so we've done the real property. The same, the next section is personal and household items. Those are things around the house. So things like the sewing machine, whatever you want that's valuable, your rings, whatever that's valuable. Next is cash gift. Do I want to give any cash gift to anyone? Here's your chance. The name you want to get the gift, the amount, and your signature. It walks you right through it, step by step. Lastly is all other assets, and that's called the residuary, meaning the rest of my estate, okay? And so it's a little complicated, but we're going to go through it step by step. So I'm going to read. It says, I adopt only one of the clauses by placing my initials in the box in front of letter A, letter B, or letter C, designating which of these I adopt. I place my signature after clause A or B, or after each clause in clause C. If I fail to sign the appropriate distributions, or if I sign in more than one clause, or if I fail to place my initials, this paragraph will be invalid. And the remainder, anything that I haven't mentioned above here, the remainder will be distributed as if I didn't have a will. Here's where you want to follow the procedures. This is serious. Comment from the gallery, serious. Comment from the presenter, yes. Okay, now we're going to walk through A. We're going to choose A, B, or C, and we're going to sign whichever one based on the number of times it requires us to sign. So A says, I leave all my remaining property to my spouse if living, if not, then in equal shares to my children. You want that? Check it. Sign it. B, if you don't want A, maybe you want B. I leave the top of, I did not get the page. Okay, good. Now we did A, now we're going to go to B. Do you want B? Check B. B says, I leave the following stated amount to my spouse and the remainder in equal shares to my kids. You want B? You don't want B. If you want B, check it, fill in your spouse's name, and sign it. What if none of them work? Maybe you don't have a spouse, maybe you don't have kids. None of them work so far. Here's your C. I leave the following stated amounts to the persons named. And you could say, say you've got 5,000 or 10,000 in assets. You can say, I'm going to give 1,000 to each of these people. So here you want C. So you say 1,000 to Jack, 1,000 to Jill, 1,000 to Sarah, and 1,000 to Nancy. And then you sign it. Okay? Easy, but it basically says choose one of the A, B's, or C's, and the directions are very clear. They might be intimidating in the first round, but it's a way to walk you through. It's trying to be simple and give you options. Say you don't like any of those options. Say, the rest of the estate, I give everything to my life partner, Sam. You can put it in. This is your will. These are your last wishes. You get to add. But but they're basically saying choose one. Don't confuse matters by choosing A and B and C.
I don't understand what the difference is between
A and B?
No, we'll go back to the first page, the real property and this property.
Okay, what the key that you're missing, and the question is, I don't understand what this means, that we've done real property, we've done intangible property, we've done cash gifts, and now they're having something like, now they're saying more. Well, this is called the rest. Anything else you've forgotten above. The rest.
Like another piece of land you own 10 miles away.
If you have forgotten about it, then there's a place for it to be distributed. Or
they're saying here that you're giving everything to your spouse. I give all my real property to my spouse.
Real, that's property.
Well, so is this property. I leave my remaining property.
Okay, so she's saying on part A, if she were to choose A, this is a good question. So let me find the right page again.
The first page is either my
So
spouse or something
it's
else.
basically the word property in this line isn't simply real property. In part A, I leave all my remaining property. Anything else not mentioned above. Property being real property, intangible property, or tangible property that I haven't mentioned above. It's all the rest, the residuary. This is the rest. If there's anything that happens to be the rest, this is a catch-all phrase so that you get to have somebody you love get what you want because it just happened to have not been mentioned earlier. It's a nice catch basin. That's what it is. It's a catch basin.
I don't understand all the initials you kept talking about in here and over here.
Yeah.
That made everything else invalid.
Okay, good. So the question is that the directions for this residuary section says choose A, B, or C, and if you, and it says, I place my signature after each clause if I fail to sign the appropriate distributions, or if I sign more than one clause, or if I fail to place my initials in the appropriate box.
It's confusing.
That is confusing, I agree. So basically, there's no place that I see that's asking for your initials. So that was why it's confusing you. And so you are not, so basically, it has said if you choose A, check it and sign it. If you choose B, check it and sign it. If you choose C, check it and sign it for every line there is for you.
Check it, just to, okay,
Yes,
here.
yes, yes.
No initials, we don't really,
I agree, the initial part is confusing, and you're right, there's no place to put initials. Excellent question. Okay, now, you think that catch basin residuary clause that we've called the catch basin for anything forgotten above, if that isn't enough, there's 2.5, the next. And so basically, it's doing everything it can to make sure that for whatever reason, things get given to the person you want to give them. So call that redundant. This next one talks about undistributed property. If I have any property which for any reason does not pass under any other part of this will, it's a double check. It's a triple check, okay? And it might scare you, but it's not. It's basically just trying to be sure. So it's a second catch basin for any overflow that doesn't get caught before. Okay? Next, we're closing in on the final part, naming if you have children. Here's your chance. Young parents, you say you die in an airplane crash and you've done a will, here's your chance to say who you want as guardian for your children. And then the next section is here's your chance to say who you want for conservator of your child. Say there's a life insurance policy and there's money. Who do you want to be the conservator? It might not be the same people you want as guardian. It could be you want, your brother and sister-in-law to be the guardian of your children, but you know that your neighbor is a reliable financial person who has watched your children grow up, and you want him or her. Okay? And you get to name ones who can be substitutes. That would be the second and third conservators, okay? Same for, okay, now this is what you want to do, even if most of people here anyway don't have kids anymore. Those in the audience who have kids, by all means, they should teach us all this in high school, that before we get on a plane, we better make sure we have a will, or in a car, because if we do die and we are parents and our kids are young, I think you probably do want to have say about who you want to bring up your children. Here's your chance to state that and increase the odds exponentially that society will honor your wish about who will bring up your children if something happens to you. That's my message to those in the audience. Okay, good. Next is, and it could be that you want your grandparent, the kid's grandparents, but say it so that if there is an issue and it does go before a court or a judge knows what it is you wanted. Do it before you go to sleep tonight. Next, I'm talking to the audience, those young parents out there. Next is personal rep for all of us. Who do we want as our personal rep? Again, name somebody who is good at following directions, getting things done on time, may be capable of doing it without a lawyer. If they can afford a lawyer, may it be a good lawyer who gets it done and gets it done economically and efficiently and expeditiously. I wish you all well with that. I understand some of you have frustrations, but here's your chance to name who you want for your first PR, and if that first PR can't do it, your second PR and your third PR. And as the question from the audience came earlier, you can name co-PRs. There's nothing in the statute that says you can't. Whether you want to is another question. The more people you have making decisions, in a way it's consoling. I've had siblings say it was consoling to be working with somebody else on this. I've also had situations where you see it sets up for fights and confusion and the right hand not knowing what the left hand's up to, and they both have the powers. Yes, sir.
Is it common to hold a PR? Because I noticed in a lot of paperwork I see held without bond.
Yes.
So is it common to have a PR provide a bond?
goes, my guess is a third of the time, there's a requirement of bond. A bond is, say, okay, the PR is going to close my estate. It's going to do an inventory, and is then going to pay my bills, and then going to distribute. And that's a whole lot of power. They're acting on my behalf for my last wishes. And so a bond is something that we might put into our wills, just say, yeah, have the PR, get a bond. So if anything goes awry, there's an insurance bond, and form of insurance to help make whole any issues, any ways that I might not be whole otherwise. Yeah. It's a form of insurance policy to make sure that there's something backing up in case the PR acts inappropriately. Squirrely. Yes, sir. Was that? Yeah, okay. Yeah. I would, if a bond, if I don't have to require a family to do bond, I'm happy, because I'm happy either way. If that's what the decedent wanted, that's what the decedent gets. It's not every day that people have to go find a bond and pay for a bond, and so I understand that's a bit of an imposition, but it's insurance, and if that's what the person wants, so be it. Yes, okay, and I want to research the bond issue too to make sure I get that right about, and what I want you to do right now is while I look up the bond issue to make sure I'm exactly accurate, you'll see, if you'll just look through the next few pages, you'll see what I said earlier about all the signature requirements. Do we want to just go through the signature to make sure we get it right? Let me do that rather than take your time, take my time. I will look up the bond and we'll get that answer for after. Thank you, sir. So basically, I signed this will on this date in this city, my name. Put your name there, okay? Walks you through it. I've really tried to, and the people who set out the initial form and how I've adjusted it and format-wise to make it user-friendly. A lot of us are trying to make it user-friendly for you. The next is the witnesses, statement of witnesses, and then witness signature 1, printed name, address. Signature 2 of witness 2, and printed name and address. And then we walk through this. The next is I, and you put the name, the testator on this day, being first duly sworn, do hereby declare to the undersigned authority, the notary, that I sign and execute this as my last will. Here you sign, right above the testator name. Then we, and you put the witnesses, Jack Smith and Jill White. The witnesses, being first duly sworn, also hereby declare that the testator has signed and executed this instrument as his or her last will, and that he or she signed it willingly, or that willingly directed another to sign for him if they can't sign, and that each of us in the presence and hearing of the testator signs this will as witnesses. Again, they're saying we're here, we're paying attention. It walks you through it. Next is the notary signs. I, in the county of Kennebec, subscribe to me, the testator, and then the notary names the two witnesses, saying they were all here signing and swearing before me, and the notary signed. You think that's enough? No. We're going to add the extra layer. So you do it, you go through it all one more time. Again, the notary says it again. It's duplicative, but it's all intended to get as much in there to save you from having to have the will question down the road, because it's so clear that everyone not just signed once, they signed 3 times. They knew what they were doing. It's beyond question. So, any other questions on that note? I would just close by saying thank you for coming. I appreciate your interest. I'm not here as your lawyer. I'm here as your friend and your neighbor, and I wish you momentum going forward. There's nothing more wonderful you can do for the people you love than to blow that trumpet clear and loud saying, this is what I want, and may they all follow you, and may it be peaceful and uneventful and beautiful and wonderful, and you've had the conversation of And may you enjoy those conversations, because I don't think there's any more meaningful conversation than talking to somebody about these very important life and death matters.